All right, good morning. We're just gonna let the room fill up here for a moment before we get started. All right, well, good morning, and thank you for joining us for our webinar on opting out after Mahmoud, how schools and parents can navigate this new landscape. My name is Lauren Groyle. I am Associate Counsel here at the Wisconsin Institute for Law and Liberty. And with me is our Education Counsel, Corey Brewer, who leads our legal efforts in this area. So for those of you who are unfamiliar with Will is a 501c3 nonprofit litigation and policy firm that works to advance limited government, free speech, transparency, and education reform across the country. To further that education reform piece, we have created what's called the Restoring American Education Initiative, and I'm just going to give a brief overview of that as well. So, the Restoring American Education Initiative by Will, or the Wisconsin Institute for Law and Liberty, is designed to engage parents, school board members, and teachers by giving them an understanding of the concerns and trends in education while providing model school board policies and other resources to produce positive change at a local level. RAE, or the Restoring American Education Initiative, has three main facets: resources for school boards, resources for parents, and resources for teachers. And then for Wisconsin public schools, Will also has a comprehensive school scorecard to give parents, community members, and school board members an idea of how their school is actually doing. But today, we are going to go over the Mahmoud case and questions that parents have been sending us on how to handle schools' responses to their opt-out requests. As you may know, Will has created an opt-out request template that parents can use to assert their constitutional rights given the recent Mahmoud versus Taylor decision. But we've received an array of questions from parents across the country who have used our opt-out form or who have requested to use have requested an opt-out using their own form about how to handle their school district's responses to those opt-out requests. So first, we're going to provide an overview of the Mahmoud decision, what it says about opt-out requests, why it's important. And then we're going to go over how to handle some of the responses and provide additional information that school boards should know when responding to opt-out requests for parents. So this will be a good presentation for both parents and school board members alike. Specifically, we're going to cover 7 different questions today. And I'm just going to quickly go through what those questions are. So, explain your religious beliefs. You have to use our form or we do not honor blanket opt-outs. Students have to respect their peers. You can't opt your student out of curriculum in subjects that are required for graduation by state standards. Mahmoud only covers LGBT materials, so you can only opt out of LGBT materials. You can opt out of gender ideology instruction or whatever instruction that you're requesting to opt out of, but we actually don't even have that in our curriculum, so you don't need to worry about it. Or, sounds good. We already do this. We already allow parents to opt out of human growth and development or sex ed curriculum and of controversial surveys. So we're going to go through each of those questions or each of those responses and how parents can handle it and how schools should be responding to opt-out forms for each of those questions as well. And then if you have any questions during the course of this presentation, please use the Q&A function at any time. We are saving dedicated time at the end of this presentation for questions. So please feel free to write that down and we will address it at the end. And with all of that being said, I'm going to hand it over to our Education Counsel, Corey Brewer, to discuss what the Mahmoud decision was and what it said about opt-outs.
Thank you, Lauren, and good morning, everyone. Thank you for joining us today. Lauren, I think we might have lost our slides. If you want to try to screen share, I'm not able to see them on my end, but I'm going to go over first what the Mahmoud versus Taylor United States Supreme Court decision said, how it came to be, and kind of what it means for parents and school board members. Probably a lot of our audience is already familiar with this, but I think it doesn't ever hurt to refresh yourselves on this, especially when these opt-out requests are happening now and districts are responding now. What did the court say? What are parents' rights? And what are the kind of parameters that parents and schools are working under now with this new, really significant precedent? So I'm going to take us back to June 27th, 2025, this past summer. The United States Supreme Court issued what really is a landmark ruling in Mahmoud versus Taylor. It was a 6-3 decision authored by Justice Alito. And in that decision, the court held that the Montgomery County, Maryland School District violated the free exercise clause by denying religious parents the ability to opt their children out of instruction involving storybooks with LGBTQ themes. So parents wanted to opt their young children out of this, and the school district said, no, you may not. This ruling establishes a nationwide requirement. When public schools include instructional materials on sensitive or controversial topics that conflict with a family's sincerely held religious beliefs, they must offer and respect a parental opt-out. So how did this case really come to be? It began in one of the most religiously and ethnically diverse counties in the country, Montgomery County, Maryland. In 2022, the school district added LGBTQ storybooks to the elementary English curriculum. At first, parents were allowed to opt out, but in 2023, the district changed course. It revoked the opt-out policy and instructed teachers to avoid acknowledging dissent, which Lauren will get into a little bit more detail later. The district gave parents no notice and no option to shield their children from the material, even when it directly contradicted their religious teachings. The books, what was in these books, just a brief overview, they depicted same-sex marriage, gender transitions, particularly gender transitions of young children, and LGBTQ identity as essential to happiness and fulfillment. One book called Prince and Knight ends in a royal same-sex wedding. Another book follows a girl named Penelope who transitions and feels affirmed when her mother recognizes her as a boy. So these types of content were being taught to very young children, early elementary school children, and they were not presented neutrally. They were framed as unquestionably correct, and teachers were told to disrupt either or thinking and dismiss religious objections as harmful or wrong. I think probably you all can see the slides. I can't. I'm just going to keep going. Um, I want to then get into, okay, what did the parents argue? What did the district argue? The parents, they filed a lawsuit arguing that this violated their First Amendment right to freely exercise their religion. They were represented by the Beckett Fund. And by forcing these children to read and discuss materials that contradicted their faith, the parents argued that the school district was interfering with their rights as parents to direct their religious upbringing. They cited a case called Wisconsin versus Yoder, and in that case, the court protected Amish parents who removed their children from public high schools based on religious objections. The principle is essentially the same. The government cannot override a parent's right to teach and preserve their family's beliefs. Now, what did the district argue? The school board said allowing opt-outs would be too difficult, too administratively burdensome. It would burden teachers, disrupt classrooms, stigmatize students. They told families that if they objected to the books, well, maybe they should think about private school. Maybe public school is not the right place for them, and they should figure out how to pay for a private school tuition. But the court rejected those arguments outright. Public schools cannot evade the Constitution by claiming it is inconvenient to honor religious liberty. And what did the court ultimately hold? The court ruled that the district's decision to revoke parents' opt-out rights and withhold notice, that substantially interfered with the parents' right to raise their children in accordance with their faith. So, as in that Wisconsin versus Yoder case, the court applied something called strict scrutiny, which what would be useful to know for our purposes is that strict scrutiny is the highest standard of constitutional review. It means the government must have a truly compelling interest, and it must use the least restrictive means. Montgomery County failed to meet that standard. And also, the court was clear when schools include material that touches on religiously sensitive topics, they must accommodate religious objections unless they can meet this very high bar. Now, turning to parental opt-outs and what this means in practice, this decision affirms a foundational principle. Parents have the primary right to direct the religious upbringing of their children. That right does not disappear in public schools. And this ruling applies to, we'll get to this as well, but we think it applies to more than just LGBTQ content. It covers any instructional content that conflicts with sincerely held religious beliefs, whether related to gender, sexuality, spiritual practices, morality. If it's instruction that substantially interferes with the family's ability to raise their child in accordance with their faith, that strict scrutiny standard applies. Now, I just want to go into briefly what resources Will has for parents, for school boards, for teachers related to this decision, because we want to make it as easy as possible for everyone to comply and for rights to be respected. At the outset, I think I mentioned this, but I just want to stress this is a United States Supreme Court decision. That means it applies in every public school district across the nation. School boards can't just ignore it. They can't delay compliance. This is now legal precedent. So the court found that the Montgomery County District's decision to withhold notice and deny opt-outs was unconstitutional. Transparency is the best safeguard. The takeaway, notify parents, school boards, please consider adopting a policy that would notify parents when sensitive material will be taught. Honor religious objections. And Will has a model school board policy that we drafted that any school district, if they're interested in the country, can take a look and consider implementing. And many school districts already have some type of controversial issues policy, but we wanted to draft something specific to parent opt-outs that very clearly kind of set forth what the expectations will be and what this will look like. A strong, clear opt-out policy to provide that framework to comply with the law, to train staff so they can comply with the law, and to maintain parents' trust. So without this, if you're a school board, if you're an administrator, without a policy like this, I think districts really do risk inconsistency. They risk miscommunication or even litigation. A policy aligned with Mahmoud protects the districts, supports teachers, and ensures all families are treated fairly. So just real quickly, what's in our Will model policy, if you want to take a look at that, it's available on our website, schoolboardpolicies.org. Our policy respects the constitutional rights of parents, aligns with the Mahmoud decision, requires advance notice for sensitive or controversial topics, creates a clear opt-out process for religious objections, and it places responsibility for resolving disputes with the school board, not making individual teachers make those decisions about whether an opt-out policy is going to be honored or not. It also includes a timeline for responses, reasonable alternative assignments for students, annual parent notification through the handbook or website, and then, like I said, staff training to ensure compliance. In addition to that school board model policy, Will has a really basic template for teachers to let families know when a controversial issue will be taught ahead of time. And we have a Mahmoud explainer By the way, all of this is also available in our newly released parent toolkit. So find this at will-law.org/parents. There's plenty on here on Mahmoud and more. It's over 70 pages long. We hope you take advantage of that. And the last thing, which I think many of you on this webinar have likely used, is a opt-out template. So again, will-law.org/parents. And we tried to create a template to inform the district when parents wish to opt out of certain topics and want to make that request. So all of that is available as well. Now I want to get into some of the responses we're seeing. I'll go over one of them, and then Lauren and I are kind of going to go back and forth. And now that the school year is in full swing, and parents are submitting these opt-out requests, what kind of responses are they getting? Does it seem like districts are complying with these, respecting, honoring them, working with parents? Is there anything we've seen that's troubling? I think, unfortunately, some districts might be tempted to deny these opt-outs or just keep parents in the dark and not provide that notice. Like I said, that is risky. Other districts might remove materials altogether. If this is too administratively burdensome and they don't want to accommodate religious beliefs, maybe they just take these materials out altogether. We've not seen that yet, but the court was clear. Telling parents to leave the public school system, that's not a solution. Public schools serve all families, including religious ones. So compliance with this is not optional. I'm going to turn to the first kind of category of responses that we've seen. And it's generally something along the lines of explain your religious beliefs. You say you want to opt out of this. How can we, the school, anticipate exactly what that means and how it conflicts with your family's beliefs? We don't want to be guessing. And to an extent, that's fair. You don't want to make the school district guess what you want to opt out of. You want to communicate with them and have a good faith conversation and be clear about what you're opting out of and that it conflicts with your religious beliefs. Importantly, schools may inquire into the sincerity of a person's asserted religious beliefs to ensure that it's genuinely held. That's fair. But the schools should not question the validity or the correctness of those beliefs. So, in other words, government entities like local school districts, they can gauge whether a belief is sincerely held, but they can't evaluate whether it is factually or theologically true, or a exactly correct interpretation of your religion. So how might parents respond to this type of pushback? I think in this instance, you want to engage in good faith communication with the school. You want to help them understand, what are your religious beliefs? Exactly what is it that you would like to opt your child out of that conflicts with your religious beliefs? I'll give just one example of what this might look like. I think in the category of gender ideology and sexual orientation, that was kind of the basis of the Mahmoud case. That's pretty clear. I think schools generally know what it means when you want to opt out of that topic. But just an example of what that might look like. For example, say a Catholic family. A parent might say or might write in an email, Catholic teaching holds that God creates each person as male and female, with sexual identity as an immutable gift to be acknowledged and accepted. This binary understanding of human sexuality is rooted in Genesis 1:27, male and female, he created them, and it opposes ideologies that separate gender from biological sex or promote fluid identities, as these conflict with divine creation and human dignity. And then I always end with something like this. In light of that, we'd like to opt out of any curriculum related to sexual orientation or gender identity, something along those lines that comports with your religious beliefs. So to sum that one up, a school might ask, is this person honestly motivated by religion? But they should not be asking, is what this person believes true, rational, or a correct interpretation of their religion? So with that, I'll turn it over to Lauren.
Yeah, thank you. So the next question or response that I'm going to cover is, You have to use our form or we do not honor blanket opt-outs. On your screen here, you'll see an example of an actual school district's opt-out form with some of the explanations on here that I'm about to discuss. So, um, while we would love everybody to be able to use our will resource, our template opt-out, it's actually more important in general to us and in actually implementing clear policies that Corey was talking about earlier, for schools to have procedures and policies in place to handle these opt-out requests. That will reinforce the vital role of parental involvement in guiding their child's education and respects the fundamental right to religious freedom affirmed by the Mahmoud case. So, providing transparent procedures and advance notice about potentially sensitive or controversial curriculum topics will foster that trust and partnership between families, educators, and administrators. So if a school wants to adopt specific policies and procedures with regard to how to handle these opt-outs, and so that they can actually honor them and protect parents' constitutional rights, that's a good thing. We want schools to do that. Um, and in those situations, parents should use the form that the school is providing. Um, However, that doesn't mean that all forms are created equal, right? And the trouble comes when the form is too restrictive or doesn't give parents an opportunity to fully express what they want to opt out of. So, we have, like I said on our screen, a couple examples of a problematic opt-out form. The school says that their form ensures that opt-outs do not include requests or directions that are not within the authority of the parent or student to require. And the form also says that parents are not permitted to opt their children out of aspects of the school's curriculum as established by the school board. And you can probably guess by some of what we've already discussed today, that's not entirely accurate in light of Mahmoud anymore. This is problematic in part because it's not within the authority of the school board to determine what curriculum, instruction, materials, or conversations conflict with a parent's religious beliefs. And in fact, if a school board was dictating what your religious beliefs are, then I think there would be an issue with whether or not they were sincerely held. So that doesn't make a lot of sense if a school were to say you can only opt out of what we allow you to opt out of. That just doesn't align with the Mahmoud case. Therefore, while parents should try to adhere to the school's policies and procedures as much as possible, by using their form, even if the form itself is flawed, but they can also include an explanation of what's missing from the form and what they would like to be included in their opt-out request that they were not able to convey using the school district's form. Um, I also included in this slide another type of response. It's related, which is why it's on the same slide. But this response of we cannot honor a blanket opt-out. And it's kind of a combination of what Corey just went over, explain your religious beliefs, and you have to use our form. What the school is likely trying to convey with this type of a response is that they are unsure about what the parent is requesting that the student be opted out of. And in this case, it might be a good idea to work with your school district to review the curriculum and instructional materials that will be used on your child so that you can opt out of particular lessons. It's also important to know that parents have a right to review such curriculum and instructional materials that will be used on their child, and that's a federal law. That's under the Protection of Pupil Rights Amendment, or PPRA, which can be found at 20 USC Section 1232H. I do include here just a quick explanation of what instructional material means because I think it's important as so that you know as parents what you're able to review. And the federal law defines instructional material as content that is provided to a student regardless of its format, including printed or representational materials, audiovisual materials, materials in electronic or digital formats. Um, but the term does not include academic tests or assessments, and that's just so that, parents aren't getting answers to tests and then giving that to their students. But my point in going over all of this is that you as a parent can go through the instructional material and specifically tell your school what units or lessons conflict with your religious beliefs. And that should satiate any response of, well, we're not going to just accept a blanket opt out. However, it's still important that you've conveyed your blanket request by providing a preemptive opt out request ahead of time, which is why we have this opt out form in the first place, because this way the school's also on notice that you would like to opt out of any supplementary lessons that conflict with your religious beliefs that may be added after you've had a chance to go through that curriculum and instructional materials. And we'll talk about that a little bit later, the tension between curriculum versus instructional materials. But I'm going to turn it back over to Corey to answer our next commonly asked question or school district response.
All right, thank you. And welcome to anyone who has joined us on the live stream on Facebook. We're going over the Mahmoud versus Taylor decision, what it means for parents and schools, and specifically how are schools responding? How can parents work with schools to ensure their rights are honored? The next response that we've seen or heard of is something along the lines of, okay, thank you for submitting the opt-out request, but the Mahmoud case only covers LGBT materials, so you can therefore only opt out of LGBT materials. This doesn't extend to other things that we may teach that might conflict with your religious beliefs as a family and how you want to raise your child. I will say right off the bat, Will disagrees with this position. I think it's very clear too in the Mahmoud decision that that is an incorrect interpretation of the case of the law. The court's rule in Mahmoud, what the court said is that any school district policy that, quote, substantially interferes with or undermines the religious beliefs of parents that the parents want to instill in their children, that's subject to strict scrutiny. So it doesn't say LGBTQ materials that substantially interfere or undermine. It says any policy that has the risk of violating parents' religious beliefs. So what might this expand into? What other categories, what other topics? If making children listen to books on gender identity passes that test, which was the facts in the Mahmoud case, if that passes that test, then we think instruction on other controversial topics can pass that test as well. And this could even impact school policies related to secret gender transitions. Will has litigated several of these cases. There are many others also going on around the country, and a few that might reach the United States Supreme Court. They're there right now, waiting to see if the court will take those cases. But you know, we have this Mahmoud decision, again, the rule. Any school district policy that substantially interferes with or undermines the religious beliefs parents want to instill. We think that any policy facilitating a secret gender identity or keeping that information hidden from parents or actively deceiving parents, those policies would pass that test as well, especially for religious families. It's actually a much greater burden on religious upbringing, arguably. So when considering parental rights claims more generally, the court rejected most of the reasons that lower courts had given for dismissing those types of claims. The United States Supreme Court rejected the idea that parents' rights stop at the schoolhouse door. They said actually those rights follow the children into the classroom, even a public school classroom. The court rejected the idea that the Yoder and Pierce cases are limited to their facts. The court rejected coercion as the limit on parental rights. It recognized that there are more subtle forms of interference that can go on in a classroom, that those are also covered. The court rejected the idea that what happens in school is merely the internal affairs of the government. And it rejected the argument that objecting parents can simply send their kids to private schools. The court said, no, that is not a solution here. And every parent who doesn't want their school secretly transitioning their child or having their child exposed to instruction that conflicts with your religious beliefs, you should opt out. You should request opt-outs. If the school won't respect the opt-out, that's when you contact a lawyer, whether that's contacting us here at Will, contacting another lawyer. We want to make sure that your rights are respected and this new precedent is complied with.
All right, the next type of response that we've seen a lot of is you can't opt your student out of curriculum in subjects that are required for graduation or by state standards. This is one that we actually hear kind of across the board, not just in this context, but reference to Wisconsin state standards all the time. We see this a lot from school districts. So I'm going to kind of answer this one in two parts, one for Wisconsin parents and schools, and then one that applies kind of across the country to everybody. But here in Wisconsin, it's important to know that there are no required state standards for instruction. I said that real slow because I think it's really important. The Department of Public Instruction, or the DPI, creates model standards that are guidance for school boards, but these standards are not required by state law. And you'll see on your screen even a little screenshot from DPI standards, DPI mathematics standards, and it specifically says that these are model standards and that locally elected school boards are the ones who adopt academic standards. I also have on the screen here the Wisconsin law for what is actually required by law for school boards to do. Um, what is required is for each school board to adopt an instructional program in several specific topics. I'm not going to read through all the topics. There's a decent list of them, but they include things like the ability to read, write, spell, and perform basic arithmetical calculations. I've never said that word out loud before. This also includes things like a body of knowledge on literature, fine arts, mathematics, natural sciences, elements of agriculture, conversations around natural resources, social sciences, including the rights and responsibilities of a family as a consumer, computer sciences, understanding the basic levels of government, including the duties and responsibilities of citizenship, the knowledge of theory and practice of physical education. These are all things that are required. There are also specific requirements for graduation, including how many credits of each course a student has to take to graduate. But again, there's no required standard of what those courses must include. That's up to the school districts on a local level in Wisconsin. So this is something that we get all the time questions about, but I wanted to be really clear and go over this piece that that's not saying that there are Wisconsin standards of what needs to be included in a particular curriculum is a misapplication of Wisconsin law. So when a school district responds that a parent cannot opt out of core subjects because a school's not able to remove or omit state mandated standards, that's misapplying Wisconsin law. And the school district may have adopted a particular policy or state standard. That's kind of a separate issue. But to be clear, there is no required state standards, and the models in the standards that exist in Wisconsin are models. But even more importantly, our parents are not usually asking to opt out of entire subjects. Parents are asking to opt out of particular lessons or instruction that conflicts with their religious beliefs. And this is the piece that applies across the country, even in states where there are required standards of what must be included in particular classes. Take the Mahmoud case. The parents in that case were not asking that their students be opted out of literacy instruction in general. The parents were requesting that certain books are not used to teach reading with their children. And the same can be true of other required subjects or required lessons in your state or at your school district. For example, if a parent wants to opt their student out of certain race instruction, like critical race theory, because they have a sincerely held religious belief that God created all men equal regardless of their skin color and that no person is inherently good or inherently bad because of their skin color, and that type of instruction typically occurs in social studies, the parent can still opt out of such instruction, even though social studies is a required course for graduation or there are required state standards for social studies. Even if a particular assignment is required in a particular course, a parent can request an alternative assignment for their child to complete so as to still satisfy any type of requirement that the school has for a completion of a credit. But the takeaway here is that a school cannot prohibit parents from opting out of instruction or materials that conflict with their religious beliefs just because the lesson is included in a broader course that is required by law or by state standards, or that has been adopted as required by the school district.
All right, moving along to the next response that we've seen, and we've seen several along these lines. Something like, "Oh, thank you for sending this. We already allow opt-outs for human growth and development curriculum or sex education and surveys. Isn't that great? We're already in compliance." Um, some schools might say this, and this is a pretty straightforward one. Under Mahmoud versus Taylor, your rights go much further than that. Opt-outs were already in place before the Mahmoud decision when it comes to surveys under federal law and under most, if not all, state laws when it comes to sex education notice and opt-out rights. So school districts really should understand that opt-out rights are not limited to sex ed or surveys. And just by the way, if you're a parent who is not receiving notice of surveys or notice in Wisconsin in particular of what will be taught in human growth and development and given an opportunity to see what your children will learn, um, that could be a violation of existing law. So feel free to reach out. Will has a contact a lawyer form. Our lawyers monitor that. Contact us, contact another lawyer, because those rights have been in place for a long time. And Mahmoud goes even beyond that. So Lauren earlier on gave a very comprehensive definition of instructional materials and what that includes. But in general, any school activity, lesson, book, policy, if it substantially interferes with or undermines your right to direct the religious upbringing of your child, that can be subject to an opt-out. So this includes lessons on gender identity, sexual orientation, instruction that America is inherently racist or founded on racist principles, or even policies that facilitate secret gender transitions of minor children. Schools cannot limit opt-outs only to certain topics. You should clearly tell your school district what conflicts with your religious beliefs and request that opt-out. And importantly, this is something that I really want parents to take away, and schools too. Communicate with the school, work with them. This is to the benefit of both sides. You want to establish a clear understanding so that on the school side, the school understands exactly what you want to opt out of according to your religious beliefs. And then on your side, you want to have a clear understanding of what the school will honor or what they will not honor, and kind of have that back and forth. It might take a while. It might be a little bit frustrating, but you want to communicate. You want to have that back and forth so that you know that they understand what you're opting out of, and you have an understanding of whether they're going to honor all of it, some of it, and just kind of keep going with that back and forth until you engage in this communication and there's an understanding of what your request is and how it will be respected.
Awesome. All right. The next one I'm going to cover here, and I think this will be the last topic that we'll cover specifically before we get into Q&A, is you can opt out of curriculum on a particular topic, but we actually don't have any curriculum on that topic, so don't worry about it. So again, kind of piggybacking off of this response that Corey just went over, like, good news, we're already in compliance. But I actually have an example, a specific example of a situation that kind of encapsulates why this is still a problem. This type of response can still be problematic. So, in this situation, a parent reached out because her child had been subjected to a conversation on gender identity and they them pronouns during instructional time. The parent then requested that going forward, the school give her an opportunity to opt her child out of such gender ideology instruction. And the school responded, you can see it on their screen, that she can opt out of gender ideology instruction, but they don't actually teach gender ideology instruction in their curriculum. Well, this is problematic, right? Because her daughter was subjected to a conversation on gender ideology, regardless of whether or not the school considers that to be a part of their curriculum or not. So, can parents opt out of only adopted curriculum and not all instructional lessons, materials, conversations, or instruction that conflict with their religious beliefs? You can probably guess that the answer to that question is no. And Mahmoud actually touched on this specifically. In Mahmoud, one of the main issues was the conversations that teachers were instructed to have surrounding these LGBTQ plus books. The court went over how to have these conversations, and it can still be highly problematic and an infringement on free exercise rights for schools to facilitate some of these conversations, especially when parents have already requested to opt out of them. In that specific case, in the Mahmoud case, the school board actually provided teachers with guidance suggesting how they respond to student inquiries regarding themes presented in these books. So, for example, this is in the court case, these are direct examples from the decision. If a student asserts that two men cannot get married, the guidance document encouraged teachers to have a conversation with the student and respond by saying, when people are adults, they can get married. Two men who love each other can decide they want to get married. Or if a student claims that the character can't be a boy if he was born a girl, the teachers were encouraged to respond, that comment is hurtful. If a student asks, what is transgender? It is recommended that teachers explain, when we're born, people make a guess about our gender and label us as a boy or a girl based on our body parts. Sometimes they're right and sometimes they're wrong. And actually, in the Mahmoud case, the school board went even beyond answering questions of students and directed how to handle questions from parents as well. The court gave the example, if a parent were to ask the school whether the school was attempting to teach the child to, quote, reject values or religious beliefs held at home, teachers were encouraged to respond saying that teaching about LGBTQ is not about making students think a certain way. It is to show that there is no one right way or normal way to be. You can see how this is problematic, and there's a reason why the court dedicated pages to these conversations and why they're problematic. So it's going beyond just adopted books that were being taught in Mahmoud. It also reached the conversations that teachers were directed to have surrounding these themes and these topics. Additionally, Mahmoud specifically references instruction and materials, not just curriculum that are presented to the students. Therefore, it's a misinterpretation for schools to assume that only adopted curriculum can be opted out of by parents. This covers a whole range of conversations, instructional materials, instruction, and curriculum. So, it's important for parents to be clear when they're requesting to opt out, to request to opt out of all of those things and communicate that back to the school. But I wanted to go over this one specifically because it's great if the school is trying to provide age-appropriate content for students in the school district. It's great that they think that they're in compliance, but it's important for parents to ensure that you're actually covering all of the bases here, not just the curriculum that has been adopted by the school board. And with that, we're going to open it up to some Q&A.
All right. I'm gonna go, Lauren, I see one in here and I definitely want to get to that. That's a great question. One of the other questions that came in was related to um, do students have to use the preferred name and pronouns of their classmates. Say there's a transgender classmate, can students be compelled or mandated to use those name and pronouns? We've heard of some school districts even saying that they will punish children for under a bullying and harassment code simply for using or refusing to use the preferred name and pronouns of their classmates. Um, this is obviously a little bit different than the curricular issue that we were discussing, but I think Mahmoud is still instructive here because if a parent objects to the use of certain pronouns or their child using pronouns that don't align with the biological sex of another student, I don't think the school can force participation in that or force a student to speak something that they do not agree with and that conflict with the family's religious beliefs. So that would be an example. Remember before I was talking about having this good faith back and forth with the school district, help them understand what your religious beliefs are at that topic, on that topic. Try to understand if the district has a policy requiring students to use preferred name and pronouns of their classmates. And if they do, will your child be punished? Can they opt out of that policy? Try to get a good understanding of how this is going to look in practice. And at the same time, I think, parents, you can instruct your children not to use, affirm, refer to students by pronouns, name and pronouns that don't align with their biological sex. Importantly, though, and we always say this, I think it's really important to still be respectful. Um, Kids should be respectful. If they do this in a way that could be construed as bullying or harassment, if it's disrespectful, then they could probably still be punished under the school's code of conduct. So free speech rights, religious freedom rights, but also encouraging children to always be respectful.
Yeah, we've gotten some really great questions so far. I'll go ahead and answer the first one here. Does Mahmoud cover voluntary conversations that teachers have with students without the teacher being instructed by the district to respond a certain way? One of the things I want to mention quickly is that a lot of these inquiries are very fact specific. So this is the lawyer answer, right? It depends. But in general, if a teacher is including conversations on particular topics that you have requested to opt out of, that they, plan to have ahead of time, it was something that they're including in their curriculum, in their instructional materials, they're giving presentations on it. Those are things that parents should be able to opt out of, regardless of whether or not the school board instructed the teacher to have those conversations. Where things get a little bit trickier is kind of in passing conversations, and I think that would have to be a fact-specific inquiry. So it would depend a little bit on the circumstances surrounding it.
All right, we have a lot of really good questions here. I'm going to try to kind of go through these rather quickly, and I'll pause, Lauren, to see if you have anything to add. But one individual says, we sent in the opt-out form you provided. Glad you found it useful and you sent that. Do we have to complete this every school year? I would say yes, because you want that transparency. You might have a different administrator or your child might have different teachers, and you just want everybody to be on the same page and understand and know what you're opting your children out of. So I think submitting that at the beginning of each school year. And then if you've gone through this kind of correspondence to have a good understanding of what are you opting out of and what's going to be respected, keep that correspondence too, document everything, because then maybe you can just forward that along. And that can create the record of what you're opting out of. Second question, or third, fourth, whatever we're on. Can we get the language you use to explain Catholic religious beliefs? Yes, this is being recorded and it will be available on our YouTube page. And then also for anyone who registered, we're going to be sending you a link as soon as it is ready as well. So that will be available, that example. Oh, this is a good one. I'll start on this, Lauren. Let me know if you want to add anything. Do you have to prove you belong to a church? Do you have to prove you have strong religious beliefs? I would say no. I think that that goes back to kind of that first explanation that I was giving. You 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 need to show, you need to demonstrate the sincerity of your beliefs. Do you really believe this? Is this opt-out really based on your religious beliefs? The school should not be asking, oh, what church you belong to? How often do you go to church? Do you pray? How often do you pray? Where does this come from? Is this right in your theology? I don't think you have this belief right based on this religion. That's where I think it starts to cross the line. So you don't need to prove how devout of a religious person you are. You want to prove that these beliefs are sincerely held.
Yeah, the only thing I would add to that is that it doesn't even need to be a particular religion. There are lots of people who identify just broadly as Christian, as Jewish, but they don't belong to a particular church. That doesn't mean that you don't have constitutional rights. You still have the right to free exercise how you believe. The only thing that they're allowed to question is whether or not that's sincerely held, as Corey kind of already mentioned. But that really just has to do with like, do you follow this practice in your everyday life? Is this something that you have conversations with your children about? Like those are the types of sincerity questions as opposed to where does it say this? How often do you go to church? That kind of a thing. Because for a lot of people, you can be religious without regularly attending a church or a synagogue or whatever comports with your religious
I want
beliefs.
to I want to expand on that too, because a question that we've received in the past is, well, what about non-religious parents? Can they opt out? What if they have a moral opposition to what is being taught, but they're not religious? Um, at the outset, that would not fall under Mahmoud. Mahmoud was a free exercise case. It concerned religious beliefs specifically. However, we think that parental rights extend beyond religious parents. So even though it's not part of the Mahmoud precedent and part of that decision and the facts of that case, it's not, and our opt-out form that we've provided is specific to parents with religious objections. You can still ask. You might as well ask the school. Say that we have a moral opposition to this, or we don't agree with this in our household. This is not how we are teaching our children about this topic. We would like to opt out. And again, be very specific about what you're asking to opt out of and see how they respond. It wouldn't fall under Mahmoud, but that doesn't mean you don't have rights as parents to direct the upbringing and education of your children. So, worth asking.
Another question, can schools have the LGBTQ flag in the hallway and the classroom? Um, does that interfere with parents' religious beliefs, or is it government speech on behalf of the school? This is an interesting question that I think there's going to be some gray area with. I don't think that everything under Mahmoud right now has been fleshed out because it is a relatively recent decision. So just how far that um, instruction, lessons, curriculum, conversations, how far that goes and what parents can opt out of, I don't think is perfectly clear. But I will say that schools, as governmental entities, do have free speech rights as well to a certain extent. And there's definitely going to be some play between the First Amendment rights of the school versus the free exercise rights of the parents. I wish I could give you a very specific answer, but I think it'll depend on some of the precedent going forward as it continues to get litigated. But also, just so you're aware, that the Wisconsin Institute for Law and Liberty will, one of our model policies specifically addresses this because we think that political or controversial displays in the classroom or in the school can be distracting to learning. And as you're probably all aware, NAEP scores are down. The math scores are the worst they've been since the test began in 2005. There's clearly a learning crisis going on. So for schools to put their time and energy and focus into, some of these more controversial or political displays for their First Amendment is maybe a misapplication of resources, but that's much more of a policy decision than it is like under the Mahmoud decision.
I'll add to that too. I don't think simply having the flag in the hallway is a violation, but what you'll want to kind of keep an eye out for, maybe talk to your child, is it part of instruction? Are they saying, "Oh, here's exactly what this flag means, and here's how pronouns are used, and how you should use pronouns?" And is it starting to become part of the instruction in any way? That's when you might want, that's when it might cross over into that curricular or instructional aspect. And I see a question here about something related to what a state board of education sent out. Will you reach out to us, the individual who included this in the Q&A? Lauren and I are going to put do we have our email addresses up here, Lauren?
Yes,
We'll put them
I
up
will
on
put
the
that up.
screen, but if you go to our website, will-law.org, right there in the middle, there is a contact a lawyer form. So for this individual, we'd love to connect afterwards. Also, um, any individual, if you have something now or if something arises later in the school year, please use us as a resource. Use our contact a lawyer form. Our attorneys are always monitoring that, and we have limited resources, but if we're able to help, we certainly will do so if it's in our area of expertise. All right. Do we have any other? We have maybe just one more here.
Yes. So for the question is asking, do we have sample model policies of for school districts or boards that require political or gender identity free learning environments? So do we have a model policy that requires schools to ensure that there's an environment free from those types of instruction? We do have a couple model policies that touch on this issue. We have a model policy on controversial issues and how parents can be notified of controversial topics, what that means. We also have a model policy on gender identity, specifically with regard to teachers and using gender identity pronouns and that sort of thing. So there's some options on our website if you want to check out our model policies. We're up to 41 now, and they cover a wide range of topics that touch on your question there.
Yeah, also social emotional learning. We've seen that category used to insert various categories of controversial instruction. So just kind of bringing it around for full circle, our approach with those types of policies has generally been more transparency, more parental rights. Let parents know what is being taught. Let them decide whether they want to have their children exposed to that instruction or not. And I think having a school board policy that clearly lays that out, that we're going to provide notice. Here's how the opt-out process works. I think that's the best way to probably do that. And I know we provided a ton of information. If you signed up for this webinar, we're going to provide not only the link to this recording, but also some links to our resources that we mentioned. So you'll get that all in one email. And like I said, Lauren and I are glad to be a resource. We love our jobs. We love the law and diving into this type of issue. So glad to be able to do what we do. Thank you all too for your support of Will. As a nonprofit, we couldn't do what we do without your support. So Lauren, anything to add before we sign off?
I don't think so. On the screen here, we have our emails. So as Corey already mentioned, if you have fact-specific inquiries or think of anything else you want to ask us, please reach out. We're happy to help.